Hey everyone, it's Rob Ryder again. Still Monday, October 5th, or excuse me, November 5th, 2012. Going to spend some time talking about this Chapter 1, Introduction to Trust. More on trust, contracts, law, and equity. Before we do that, an interesting form that a brother sent me. Daniel Joseph sent this to me over the weekend. It's PD space F 1455E, which is a request by a fiduciary for distribution of United States Treasury securities. The following, let me make it a little bigger here. Following instructions in filling out this form. You should be aware that making any false, fictitious, or fraudulent claim or statement to the United States is a crime that is punishable by fine and imprisonment. Print and ink. Okay. One or more fiduciaries, either an individual or corporate, must use this form to establish entitlement and request distribution of United States Treasury securities and or related payments to the person lawfully entitled due to termination of trust, distribution of an estate, attainment of majority, restoration of competency, or other reason. Attainment of majority. Right now we're seen as infants. And I know that people say, well, if you're an infant, you know, that makes you a decedent. Well, it really says if you're an infant, you can either be a decedent or an owner. And you're an owner, and now, by checking this box here, you've attained the age of majority. Well, that was easy. Right? You can only check one box, apparently. So that's what I'm doing. Or will be doing when I get around to it. Distribution of securities and payments. Right? Distribute to, put your name in here, your social security number, and your address. And then you have to go down here, and there's the hard part. Description of securities and or related payments. Damn it, what are they? I just don't know. Well, let's keep going. Right? So here's just another one. This is a continuation, another Part B. All right, same thing, another one. Yeah. And then we get down to signatures and certifications, right? So we certify under penalty of perjury that information provided, yada. We bind our heirs, legatees, successors, and assigns jointly and severally to hold the United States harmless in the account of the transaction requested and indemnify unconditionally and promptly repay the United States in the event of any loss which results from requested, including interest, administration costs, and penalties. All right, so you give me my estate, I'll pay the cost. All right, so you got to do that. All right, so applicant's title, I guess I'd call myself the owner. What do we have up here? Let me look again real quick. Shoot. Yep, distribute to, okay. So that's all there really was, just that and that. And now this page here, and here, this is pretty official looking. I certify that, name of the person who appeared, whose identity is known to me, so this is what the notary is going to do, right? That's a pretty professional looking notary statement. And then this is another one. So this is, there may be more than one notary, so they have more than one piece of paper. But it said only one had to do it. So the thing is, now let's get down to the instructions, right? And we had this thing here where enter the name of only one distributee in each Part B. Okay. So just one person, it's yours, so there's only be one. Provide the registration of each security, check or account. Also provide the account numbers, if any. Now, the reason I'm saying this is this shows you how to fill out that block where, they're asking for all this information. But it says here, if unsure what to provide in each of the areas, furnish all identifying information in the space for registration. Okay, well, you got a certificate of live birth or you have a birth certificate. It's a security, right? It's a bond. I think if you put that information here under registration, don't fill out any of these other blocks, just put it right here, whatever the information would be that would go there. because you are a fiduciary on your own account. They make you a trustee all the time, or they attempt to. They don't want to be the trustee. Well, here's a chance you can be the fiduciary. Say you've attained the age of majority, distribute it to yourself. In the registration block, put the information on the birth certificate, the one on the bond paper. Extent of distribution in full. You want the whole thing, right? You don't need to say how much, just say in full. And then you got to do the signature page. Sign it here. Applicant's title, that's one thing I'd want to be careful with, what the applicant's title is. Date, time, phone number. Right? You're going to certify that it's yours. Well, you're not lying. No worries. So anyways, I'd never seen this form before, but again, this is called the request by fiduciary for distribution of United States Treasury securities. PD space F 1455 space E, Department of Treasury, Bureau of Public Debt. They may even it's got an OMB number on it, right? So you guys know more about this stuff. You can tell me what it is. I'm going to talk about the easy stuff. So before we get on with equity, right? Or as we get on with equity. So in exercising judicial discretion as opposed to personal discretion, courts apply established principles of equity to the facts presented by the particular case. So equity courts have established principles of equity. Those are called the maxims of equity, and they're applied to the facts presented with a particular case. How can you take a maxim of equity and use it to your advantage? Beyond fundamental common law principles of deciding like cases in a like manner based on precedent, right? So like for like. So beyond that fundamental, there is also serious due process consideration that an equity court must factor in decision-making process. A due process of law. Again, in law, apparently they don't care how somebody got a contract. Threat, coercion, duress, doesn't matter. If they're holding the paper, they're the owner. You can't get a remedy in law if they're holding the paper. Right? So, when that privateer pulls up behind you and flashes those lights, from that moment you've just been falsely arrested. And it just continues from there, right? Because you're not going to get due process. The first principle of due process embraces rule of law which contains standards that can be known in advance, conformed to, and applied rationally. The doctrine of supremacy of law is a doctrine that sovereigns and all its agencies are bound to act upon principles not according to arbitrary will, are obliged to follow reason instead of being free to follow caprice, right? The doctrine of supremacy of law, that the sovereign and all its agencies are bound to act and follow. That never fails, man. Frickin' phone always rings when I'm doing this. Okay, so back to this book here. Give me just a second, because my answer machine will go on in just a second. Tick tock, tick tock. All right. Let's go down here. Now the interesting thing is whenever they talk about trust in this stuff, now and again this is from the University of Oxford in England, I think they might know a little bit about trust. But it's always tied with the Court of Chancery and the maxims of equity, because as it turns out, trusts are the jurisdiction of equity. The Court of Chancery is the one that devised the thing. And all a trust is a unexecuted use. Okay, so in contrast to the rigid and unbending application of the common law, the law of equity, called such because of its basis on principles of impartiality and fairness, seemed to be almost entirely dictated by the Chancellor's own personal moral code. Well, the guy used to be a bishop. The guy who started it was a bishop. And this Sir Thomas More ended up becoming a saint. He was a closet Catholic. This in turn led to the development of a number of equitable rules or doctrines and the formalities and maxims of equity. As a result, the Court of Chancery also began to base its equitable judgments upon precedent and Court of Common Law did. So the Court of Common Law is bitching because it used to be just whatever the chancellor said. They said it's unruly, they got no rules. So this guy, Thomas More, came up with the maxims of equity. He established the doctrine so that it could operate as a form of law. And we know about the unification of the courts. Again, it's two different bodies of law administered by the same people wearing two different hats. You got to go to equity for equity. You can't go to law. And when you walk in, they assume you're going there into law. And if you're looking for money, right, that's in law jurisdiction. And before I forget, on the video I did just before this, it was saying in there that anytime a jury is involved, it's a money decision, right? So, it's for somebody looking for money. Well, how come when you go to, somebody gets indicted for IRS and goes to a grand jury, they go to jail for putting in a false claim? It had nothing to do. They're not asking for any money. Doesn't say you owe any money on there. They're saying that you put in a false statement, which is something that is only determinable in equity. So it couldn't have been an equitable court because there was a freaking grand jury involved. I got to think about that some more. But I know the grand jury's involved. If there's a jury involved, it has to do with money. It is worth stressing that this fusion of common law and equity was only an administrative advance in the law. It was not a melting together of the two systems. The rules of equity and common law are still entirely separate and distinct. It is simply that they can now both be administered under the same roof. It used to be you walked into two different buildings. Now you walk into one door. People wearing two hats. This system still forms the basis of our courts today. So the equitable maxims. It was mentioned above, the development of the Court of Chancery into a fully fledged legal system entailed the development of a series of equitable maxims. These maxims of equity are, in effect, a set of guidelines or standards devised by a court of equity as an aid to deciding cases which come before them. There are quite a number of equitable maxims. You do not need to know them by heart. As you will see from the various examples given in the following text, there is no shortage of evidence of the maxims in use. So what's the first one? Equity will not suffer a wrong without a remedy. The first equitable maxim is linked to the very origins of equity. And the very origins of equity is Jesus Christ. He brought equity. He brought the new law compared to the old law, which was the Mosaic law. And he was the Redeemer. The maxim alludes to the fact that equity was devised specifically for the intention that it should act as a supplementary or alternative court of justice, or an alternative, a court of justice, court of justice, where the common law is not able to provide a remedy, because the dude does have the contract, and it doesn't matter he committed fraud to get it. That's what the law says. Got to go to equity. So as we shall shortly see in the case of the trust, an invention of equity, right? So the legal owner of the property will be prevented from asserting their rights in respect of the property because they are deemed in equity to hold the beneficial or equitable interest in the property on trust for the beneficiary. So they don't have the equitable interest, they're just holding it. So they don't have the right to use it, they're just holding it for somebody else. Well, they don't have the right to it. They may be using it, but they don't have the right to it. He who comes to equity must come with clean hands. This is probably the best known of all equitable maxims. The idea behind this maxim is that a person who acted wrongfully cannot then seek to rely on a court of assistance in bringing a claim. So a cop rolls up behind you, threat, coercion, duress, gets you to sign a contract. He comes into court and says, look, I got a contract with a dude. He signed it, see? The law says, as far as common law is concerned, yes, you did. You going to pay it or not? Right? So, but he's trying to do that in a court of equity, and you need to say, well, he didn't bring. They're trying to do it in a court of law. So, because he has the contract, and you need to take him into a court of equity and say, well, he has it by a falsehood. The doctrine itself is designed to prevent legal owner of property from asserting their legal rights against third party where it would be unconscionable or unjust. The requirement clean hands does not mean that someone or generally morally reprehensible character will be barred from using a court of equity at all. However, the maxim will only apply if there is a genuine link between the claimant's wrongful act and the rights they wish to enforce. So yes, they can come there. You'd better make the right argument. He who seeks equity must do equity. So a person who wishes to claim the equitable remedy of specific performance, for example, thus forcing the defendant to complete the terms of a contract in accordance with their agreement, must also be willing to complete all their own obligations under the same contract. So when you bought a house, the grantor signed a sales contract and you signed the sales contract. Well, maybe you have. That's what happens when you acknowledge the warranty deed. You've just signed the contract. Well, now I want them to perform what the contract said. And the contract said he was giving you the rights, title, and interest to the property. So give me the title. All right, that's the specific performance I want. I don't want a money judgment. I want the title to the property. Well, what did you have to do? You had to give him $10 and other valuable consideration. Well, the evidence is already there. You gave him the valuable consideration. And on the paper, on the warranty deed, he says that he's already been paid, that he's been paid in hand, the $10. You've met your obligation. They haven't met theirs. They haven't given you the title. Equity regards as done that which must be done. This equitable maxim is significant because it means that two parties contracting to perform certain legal actions will, in the eyes of equity, be considered to have carried out those actions from the moment the contracting to do them, rather than when the contract is actually performed. Right? So from the moment you both sign it, it's done. From the moment of exchange of contracts, when the seller and buyer enter a legally binding contract to sell and purchase property, the buyer will acquire equitable interest in the house. You have equitable interest right now. Albeit that they do not become legal owners until the formal legal transfer of the house is completed. And that's the part that hasn't happened yet. They haven't transferred you the title. Equity follows the law. The best example of this might be where two people share ownership in a piece of land. In the absence of a declaration to the contrary, at law, the two people will automatically own the property as joint tenants, meaning they both hold the property together as one joint owner and no individual shares in that property. If the two people approach the court of equity for clarification as to the beneficial or equitable ownership of the property, the court's starting point will be that they own the property as joint tenants in equity too. It will only be on the provision of evidence from either party that the position should be different in equity that the court will depart from the common law option. Now this is very, very tricky, and I think this is what this means. Right? The joint tenant isn't your wife. The joint tenant is the guy that's going to be holding the frickin' title. Right? In the absence of a declaration contrary to law, the two people will automatically own the property, right? Well, if you don't have the title, they have legal title and you have equitable title, so you both own it. So you're joint tenants, and that's how they keep it out of your hands. You and the title company are joint tenants. As one joint owner and have no individual shares in that property. If the two people approach a court of equity for clarification as to their beneficial or equitable ownership of that property, to their beneficial or equitable ownership of that property, the court's starting point will be that they own the property as joint tenants in equity too. Well, in equity too, equity also, compared to what? So again, the fact that the title company is holding the title makes them a joint tenant, which means you're never the owner, you're just tenants. And that's why you pay property taxes, I guess. Equity will not permit a statute to be used as an instrument of fraud. Well, this happens on IRS cases, 18 USC whatever they put down, right, that they're going to use. But it's being done in fraud. First of all, the damn thing's never been passed. Okay, so If they're using a statute against you, it doesn't matter if they're doing it in fraud. Equity looks to substance, not to form. The maxim describes an important feature of the court of equity, which is that it is able to look beyond the external appearance of any state of affairs that exists between the parties and make its judgment based on the position of the parties as they generally intended it. Deed of trust. The thing that you sign with, well, between you and the bank and a trustee for the res, the money and so forth, right? You didn't mean that to be a gift, but you're the only one who signed the contract. So it's a unilateral contract, and that's just a gift. They need to sign the contract and send it back to you for it to be a binding bilateral contract. Well, however, somebody's holding a piece of paper that you gave to them, so he gave it to me. I got a piece of paper says so. And unless you rebut the presumption that it wasn't meant to be a gift, it's going to be seen as one. However, the court saw through the pretense and held that regardless of what the parties had called the agreement, it was nevertheless a lease, and therefore the tenant is entitled to full protection of law under proper statutory provisions. This is like your deed of trust mortgage, no matter what they call it. When you look down just above where you signed your name, it calls it a security instrument. Doesn't matter what the title is, doesn't matter if they call it a deed of trust, security deed, whatever. What it is a security instrument. And therefore it's not the lien they try to make you think it is, because if it was a lien, it would be called a lien. It wouldn't be called a security instrument. A security instrument is the instrument that is the security for the lien. When the lien's been satisfied, the security is returned to the owner. What's on the deed of trust? Two types of property. Real property being the house, because you're going to write down the description of the house property. That's the real property. And personal property, which was the promissory note and all the payments. Their conversion and gain. Those are supposed to come back to you when the lien's been satisfied. Equity acts in personam. This maxim derives its historical distinction between the two courts of the common law and equity. During the time in which the court of equity was developing, one important distinction between equity and common law was that whereas the courts of common law made judgments over property in dispute, an action being brought in rem, that is, over the thing, right? So they were making judgments over property in dispute, over the thing. The court of equity made its judgments in personam. In other words, judgments are made against the individual. The practical effect of this was that the courts of common law had ability to adjust ownership rights and property, giving all or part of the property in dispute to the claimant. They have jurisdiction over the thing. And unfortunately, they have the legal title, so the courts of common law are going to give it to them. The courts of equity, on the other hand, had the ability instead to require an individual to obey their judgment, in default of which they would take away the person's liberty by putting them in prison, issue fines until such as they obeyed their edict. So, if an attorney's coming after your house, right, he's coming after the thing. He's coming after the paper. And you're going to go to equity, and since he's the plaintiff or acting as a plaintiff, I guess he's the one that we're going to go after in persona and say, well, I don't believe you have a contract with the bank. If you can't produce a contract, then you're what do you call that word? Misrepresenting yourself. And further, the bank hasn't signed the deed of trust, so they're in breach of contract. And you tell the court of equity that and say, well, you're absolutely right. And they're going to tell the attorney, stop, or we're going to put you in jail. Give him back his property. You will run across a type of injunction remedy called freezing injunctions, right? So one of the things that a court of equity can do are injunctions, right? They can stop an ongoing proceeding, right? This is where the the writs of the king. Can't remember the word. Starts with a P. Anyways, writ of mandamus, writ of quorum warranto, writ of Sarah something or other. There's like 5 of them, right? They're prerogative writs. The prerogative of the king. Or a subpoena instead of a show cause summons, they're going to give a we command subpoena. We command that the defendant bring in the record so we can all take a look at it. We command that the defendant come in and take an oath and state his claim. The making of such an injunction is possible because equity acts in persona, and therefore the injunction is made by the court against the person, not against their assets. Equality is equity. The equitable maxim, equality is equity, ensures that there's a dispute over property for which more than one party has beneficial interest. The property will be divided equally, unless there is evidence showing that the property should be divided some other way. Okay? Equality is equity, right? So if there's more than one person with beneficial interest, it gets split equally. Delay defeats equity. If a person wishes to bring a claim in equity, they must do so without delay or otherwise risk their claims being rejected. This means a person who delays unnecessarily making a claim in equity could be found guilty of acquiescing to the conduct, complain, fail to do anything about it. Alternatively, their claim could fall under the doctrine of latches, where there are some delay in bringing the action. The maxim delay defeats equity is often not required because of statutory limitation imposed on bringing an action by the limitation 1980. You can find out more about the Act, okay, and latches in Chapter 13 on breaches of trust. See, if they commit fraud, I don't think there is a statute of limitations. What they're saying is, if you lost your house in foreclosure and they sold it to somebody else, they're not going to give you the house back, right? You're not going to get that house. What you're going to get are damages. If you want the house, you need to come soon. Equity will not assist a volunteer. A volunteer in this context is not a person who helps out at the cake stall at the local village something or other. In equity, the term volunteer has rather different meaning, which is that a volunteer is someone who receives the benefit without consideration. In other words, that person does not give anything in return for the benefit. They are a recipient of a gift. Unilateral contract. If nobody else has signed a contract, they haven't given any consideration. What's the consideration on a contract? In law, a contract under seal is a promise. That's the consideration. That's good consideration. Better than valuable consideration. Well, nobody signed the contract from the other side, so they haven't given any consideration. It's not a valid binding contract. It's simply a gift. Having done nothing to return it, the volunteer has nothing to enforce against, but put simply, there is no bargain. All right, they didn't sign the deed of trust. Equity will not perfect an imperfect gift. This maxim of equity is closely related to the maxim that states equity will not assist a volunteer. If a person makes an imperfect gift, that is a gift which lacks the formality required at common law, the maxim says the equity will not assist the intended recipient of that gift. This equitable maxim is particularly relevant in case of gifts of land or shares which require a process of formal transfer rather than mere physical delivery of the object in question. Again, right? Deed of trust. They haven't signed it. Imperfect gift. That would be if it hasn't been done lawfully, right? So not enough witnesses, something like that. Equity abhors a vacuum. The idea behind this maxim is that it goes against the principles of a court of equity for a piece of property to be left with no beneficial owner. This might be because a trust has failed due to the identity of the beneficiaries not being ascernible, or in situations where there is a surplus property left over after the trust has come to an end. In such circumstances, the trustee are unable to keep the property for their own benefit, and so the property in the trust results or returns, in most cases, to the original owner of the property, leaving the trustee holding the property on trust for them. So, right? They haven't seen us, right? So that's the KV Act, haven't appeared in 7 years. Let's say your mother or father died. There's a death certificate, right? Nobody's ever claimed dead. All they do is, if anything, right now, they've claimed you as a decedent. And a decedent is presumed dead don't have a body, nothing to put a toe tag on. Well, what about when you do die and they put a toe tag on you? Well, now you are dead. And the estate should pass on to your heirs. But what they do is they put the death certificate and they put it in the register of deeds. So it's just on deposit. It hasn't been recorded. And again, I think it's something you take to the court of equity and say, hey, I'm claiming the rights, title, and interest to my share of this estate. And we need to take the death certificate from the register of deeds into the chancery so it can be entered into the book and they can give you your share of the estate. Equity will not want for a trustee. The court of equity will not allow a trust to fail simply because a person creating a trust has failed to appoint a trustee. Right? So somehow we created a trust. How do you create a trust? You sign a piece of paper and give them the legal title. The trust has been created. Hasn't been executed yet. It's an unexecuted use. Nobody on their side has signed it to send it back to you. Equity imputes an intention to fulfill an obligation. This maxim dictates that where a person is under obligation to do one thing, but they do something slightly different instead, their action may be treated as close enough approximate to the required act to fulfill that person's obligation and equity. All right. I don't really know what that means. Where the equities are equal, the law prevails. This equitable maxim overlaps the maxim of equity follows law, which was mentioned previously. The meaning of this maxim simply is that the person in possession of the legal estate will get priority over any prior or subsequent equitable interest. So when both parties in dispute are equally entitled to obtain help from the courts of equity because their equitable rights are equal, the party who has the law, who has the legal title, in his favor will succeed. Right? So if he has the legal title and he has it lawfully, then he's going to get the benefit. Again, they don't have it lawfully, so you need to say, well, he doesn't have it lawfully. Fraud was involved. They haven't signed the contract. There is no mortgage. Show me the mortgage or return me my property. I want the title deed to my land. Where the equities are equal, the first in time prevails. This final maxim simply states that what may seem obvious, which is the case of competing equitable interest, the interest which is created first will take precedence over the others. The best example in this case is someone who takes out a second or third mortgage over their house. Okay, well, the best one to me is you have the beneficial interest in your all capital letter name landed estate. Yours is first in line, first in time, because your interest started from the day they started the estate, from the first day it was funded. Right? So anybody else who thinks they have an equitable interest in it is after you. And that's why they need you to die, because like deed of trust, as long as the mortgagor, trustor, is alive, they can't sign it. But once they die, they can go ahead and take the benefit. So, anywho, and then this goes into trust, and I'm not going to talk about that right now, but more on that stuff later. I just wanted to go through the maxims of equity. Again, the idea is I'm trying to get to the point of being able to write a very simple petition to a court of equity into the jurisdiction of equity for an equitable remedy. Using these maxims of law, which, these are the precedents of equity, and you use these as the principle, and you fit your facts around it, and you take it to the right window. We're going to see if that works. Okay.